Get started. Hello and good evening. Thank you everyone for joining this webinar. Uh, a very quick check. I know this is if someone can type and tell that's good enough that I am audible and I am clear. Whatever I'm speaking, you're able to hear me clearly. If I can get any feedback on that.
Feedback.
Thank you very much, Nine.
Perfect.
Yeah, wonderful.
Thank you.
Thank you. That's a good feedback there, so that we can go ahead and start. Thank you. That was overwhelming. All right. So welcome to this webinar session on DPDPA. So before we get into the discussions on the seminar, a very short introduction about myself. My name is Suresh Iyer. I'm the founder and CEO for CyRax. CyRax is an acronym for Cyber Risk Advisory and Consulting Service. We started in 2017 after 25 years of stint in the industry, in the leadership positions, and from there, in the last 6 years, we have completed over 2,000 engagements, have over 650 plus clients, about 160 people, and fairly well recognized in the space that we have been operating thanks to the great support that we have had from our clients and wonderful people around who have helped us grow. So I also have with me Venkat Iyer.
Hi all, this is Venkat here. I'm the practice head for risk advisory services and fintech services in CyRax. Been with CyRax and been with their growth for the last 4.5 years now. And been in the IT infosec space from 2010. So it's a pleasure meeting you all here today. And it's going to be a great session. It's going to be a very good learning for all of you guys, hopefully. And feel free to type your questions in the Q&A section in the chat window, and we will take as much questions possible and try to answer everyone in the end of the session. So I think I'll just start the slides. We'll go with it.
Wonderful, and thank you so much again. And we're so happy to see you all here in this webinar. So for the next 40 minutes or about 35 minutes or so, I'm going to speak. And if you have questions during them too, and if I can answer them through the way, I will continue to do that. But otherwise, we at no later than 3:45, 4:45, we will have the Q&A session. And my objective is to get it by 4:40. At worst, no later than 4:45, we'll have the Q&A session. All right. DPDPA, Digital Personal Data Protection Act. Now, it is an absolute sense of fulfillment for privacy and security professionals to see that India has finally legislated a world-class legislation in place. And it's a matter to be extremely proud about. And how, I'm just going to take you through a little history of this. So, before 2010, what were there? The key provisions were of privacy. Was it covered under law? Yes, it was. It was under the IT Act and the IT Amendment Act that was there, and which had an overarching functional aspects of IT components into it. It was not addressing a privacy aspect per se. Our current IT Minister, Rajiv Chandrasekhar, had raised a private member bill, and that was rejected in the parliament. It was not sustained. And then a PIL was filed, uh, and that took, it was a long legal battle, and then in 2017, Supreme Court recognized and said privacy as a fundamental right. I think that's a historic judgment that happened. Privacy as a fundamental right is the basis for the law today. And that happened by Supreme Court acknowledging and saying it so. Now, from there, Ministry of IT released, a Sri Krishna committee report and proposed a draft bill. So consultations were held from 2017 onwards. Various consultations happened, and the revised data protection bill was introduced, and it was referred, and because of the because of the political maneuvering that it was required to have this in place, a joint parliamentary committee, and as Bangaloreans we can be proud. Our South Bangalore MP, Tejasvi Surya, was part of this committee, and so as Bangalore, we can be proud of a lot of things. Rajiv Chandrasekhar is from Bangalore. The bulk of the contributions of how this bill has to be drafted came from people in Bangalore, and South Bangalore MP Tejasvi Surya. Bangalore has a very important role in this particular state, so proud to be part of that. And finally, JPC produced and gave the draft bill in 2021, and that went through a number of changes, and finally it was withdrawn. And they released a new draft in 2022 for public consultation. And today, it is a moment of history that we have a legislation that's been that has been passed in both houses of the parliament, president's assent, and then finally the gazette, and today it's a law. And it's such a long process, but a historic moment for all of us. So we've always prided to say that the pinnacle of privacy regulations. People said GDPR as one, or California privacy law, or Canadian PIPEDA, Australian Privacy Act, Singapore privacy. So all of them have been as good reference points as security and privacy practitioners. We have looked at all this, and I can today proudly say that Indian legislation is today probably standing with all of them or slightly one step ahead of all of them today, right? Now, the fundamental difference between the Indian IT Act and the DPDPA is, IT Act was an overarching act. It did not have specific protection interests on the individual privacy rights. And I think from 1999-2000, when that was drafted and released, to today, there has been a phenomenal change in the social media consumption and digitization of the economy. And how many of us can imagine that we have not gone to an ATM to even withdraw cash, and we have not transacted cash at all, or the cash transaction has come down 90% for all of us, or sometimes even more. So with tech geeks in Bangalore, I can say that I've seen that people have said that I have not gone to an ATM for the last 8 months, or 9 months. And people have just not transacted cash.
Even a 5 rupee transaction happens only through UPI.
UPI, yeah. And so digitizing our economy has played a very, very important role. and digital retail, online retail, look at how it has changed the way we consume things across. And all e-commerce, our digital platforms, everything that we're talking about in the banking, payments, and the e-commerce space is today in the digital world. Now, all of this has multifolded the way in which the end user data are used by IT systems, by large players, and the collection of data and aggregation of data is getting humongously large. Now, and therefore, the need for such a very detailed regulation only to specify the end user rights and what needs to be done by various people who are holding that information. That is all this act is all about. So it has a number of provisions of how notice needs to be done, how consent needs to be done, what are the procedure in case if there is a breach, if minor data is present, how parental consent needs to be obtained, what is the grievance process, and who are having the exemptions. And let me tell you, if government today holds 60 to 70% of all this information is present in some form of government records, are they exempt from DPDPA? No. There are the exclusions for some the exclusion very, very specific, and the circulars have not come out yet. So that just to backtrack again, the act has come, but how it needs to get implemented will be through various circulars from various nodal agencies. And therefore, is this the final blueprint? No. This is the large roadmap that the government has shared today through this act. What needs to be done, to be seen, is to how this is getting implemented at various levels, and all of that needs to be seen by various circulars that come from time to time. So at this point, is it too nascent to talk about the final implementation and its implications? I would say partially yes, but however, we can get prepared from now. And this webinar is intended to provide some light on that aspect.
Okay.
So I was quickly going through. I'm seeing some of the comments. Yes, we will be addressing some of the aspects of the data fiduciaries and what are the consequences. Yes, we will be doing that. And thank you for your questions. We keep it coming, as much as it doesn't distract our regular flow of discussions. We'll continue to keep looking at your questions and see how it is appropriate for the. So this act keeps the data principle as the king. It is the end user, you. Okay, your data, which is present in various forms, the kingship has been given to you, and who you give the data to becomes the data fiduciary. The data fiduciary is the person who collects the data from the data principal. He could have the data processing done by himself. He could have the data processing sent to another company or a set of companies who become the data processor/processors. Now, this is a very important aspect that needs to be understood, that the primary responsibility to hold the data is the responsibility of the fiduciary. So who collects? Suppose you write a bank form, your KYC form. the bank is responsible for protecting your data. Now you write this information, and a direct selling agency of the bank is operating on the bank's behalf. The DSA is liable to the bank, but the bank is liable to you to provide that. So that's the crux of the delineation between a data processor and a data fiduciary. Now, you know, there are number of discussions on cross-border things, but we'll keep that aside. Essentially, the data fiduciary responsibility to handle the entire life cycle of the data. So at the start, to take a consent. Now, if you have modifications, you will need to have the right process to modify. You will need to take the right to process, and more importantly, if you have collected the information for the purpose of insurance, you shall do only insurance only. If you have collected the data to do only your mutual funds, it shall be done only for that purpose. And if for any other upsell, you shall take the permissions of the data principal to do that. As long as you take consent, you have the ability to do that, but this act makes that provision null and void to directly assume that you can do cross-selling using that information. It requires explicit approval. Now, these are things that have been made very clear. Okay, now there are a few things that need to be understood. While all this governance has been done, what is the government set up in terms of how are they addressing and governing this? They have set up a data protection board. The data protection board, is it is just like how a website is the office that it operates. Data protection board also will be a largely functional virtual office, but we don't know where they are going to place a back office for that. But the data protection board is coming. The appellate authority, the telecom appellate authority, has been referred for this as well. So this moves, the data protection board will provide, or it can move in from the DPD's discretion into the appellate authority. The appellate authority from there goes into the Supreme Court for escalation of the grievances or complaints there from there on therefore. I'll quickly stop and see what are the questions. Can a DPO also take an additional role of consent manager, or is it a separate position? Okay. Data fiduciary restricted only to principals or data principal.
I found interesting.
Yeah, so interesting questions. Quickly, I will answer Rahul's question here. Yes, the DPO can also function as the consent manager, but we'll take that questions later. But interesting questions coming up. Thank you for that. We will continue to go forward.
I think this.
Yeah, go ahead.
Yeah. So this. I think in continuation to what Suresh was saying, as of now, the government has not really called out as which countries are whitelisted countries or countries allowed to store or process the personal data of the data principles of India, right? But however, the law at this point is looking at specifically is applicable for processing of any kind of digital data within India, and this also includes, let us say that an Aadhaar data is taken in a hard copy and then scanned and turned into or digitized. So it still applies, right? So the data that is collected online in digital form or is collected offline and eventually digitized, the complete law or the full the length life cycle of the data privacy law applies, and it also applies to any activity that of the data principles within India is being carried outside, right? So, but again, at this point, like I said, which countries can are allowed to process data collected from data principles within India is not clearly called out. So we'll have to wait as the board is being created and for the details to come in. So
Yeah, at this point in time, the minister made a clarification on that, Venkat, that at this point in time, they have not restricted per se anything, but as the nature of this one evolves, there will be specific circulars on blacklisting and whitelisting of that.
okay, yeah.
But
Yeah, I think this is an interesting slide, and I know a data pointer slide. Now, what are the key terms in the the privacy bill or the digital personal data protection bill, and as an organization, what is important, as a end user, what is important, right? So the key terms or the key things are data principle. Data principle is nothing but the end user or the consumer from whom of the whose data is being taken, processed, or collected, right? And then comes the important is the data fiduciary. Data fiduciary is the organization or even a person who's collecting the data, personal data of the data principal with their consent, or rather, they have to collect with their consent. And
now, to Preetham's question, that what will be the role and responsibility of the I saw Preetham
yeah, very
asking one
interesting
question.
question. On behalf of the client, if I collect
So,
the data,
so if you are collecting on behalf of the client, if you are explicitly saying that you are doing it on behalf of the client and you have, then the client is responsible as a data fiduciary. But if you do not make that claim and you are collecting data, then you become the proxy fiduciary, and therefore you have all the liability of collecting the data.
yes, and you should have the explicit authority from the fiduciary to do that as well, right? And so data processor, let's say if a data fiduciary is going to collect data and send it to another third party or a person or an organization, they become the processor. Now, the rights of the data principal have to be taken care in its fullest form by the data fiduciary, right? So when I say the rights of the data principal, the right to access, consent, let us say I want to change my data that I have given it to a bank tomorrow, then the bank or any organization acting as a data fiduciary should have systems and process in place to correct my data, update my data, and right to erasure, nominate. So these are the rights of the principal, but who implements these rights of the principal, or who is ultimately responsible to make sure that these rights of the principal are indeed available, made available to the principal, is the data fiduciary, right? So data fiduciary, potentially organizations, very rarely it will be a person or a single person, but potentially organizations, data fiduciary have a very, very important and a large role to play in the overall, compliance, and also the maintaining the privacy of the personal information of the data principal. So it is right in its fullest form, right from the collection of data in its full data life cycle till the data deletion or disposal, if I can say. They have to take care of it and also make sure that the data principal has access to the data whenever required, and also easy access to the data fiduciary to make sure what data has been taken, whether it is profiled in a further way, etc. And so that's the key terms in terms of the data. Three main important key terms: principal, processor, fiduciary, and critical personal data. And in terms of the exceptions, right? I think Suresh was mentioning about the exceptions, but before going to the exceptions here, and I think as a data fiduciary, I think many questions I see around what is the role and responsibility of the data fiduciary. To put it very simple, take care of the rights of the data principal, be aware of what are all the rights of data principal, and make sure that you are going to give it back to them or give it to them, or make it available for them. The second I would say is the complete life cycle of the data, right? From the collection, then you process it, store it, or sometimes store it and later process it in your internal systems. Then you have to store it for a longer time, archive it, and then delete it. This is a typical life cycle of a data, right? At each point, making sure that security aspects are taken care, privacy aspects. This may include anonymization of the data, pseudonymization of the data. The anonymization usually comes when you want to delete data and later how not to make sure that it is not pointing to a specific person. So yeah, take care of the data in its fullest life cycle. Now coming to the exemptions, right? It's not like the government or the central government is completely exempted
So I
from.
think this is where, the minister made a clarification. See, today government holds in various forms, the digital form of, end user data is present in government records in plenty. Are they exempt from that? No, they are not. But but they have said that certain functions will need to have some exemptions. And for the for startup companies who have not implemented that yet, they have given some timelines to say when they can, how long they will be given time before they can, before this law will come into effect for them. So those are some of the minor exclusions, but the government is not exempt largely. Uh, so the government's primary role in the data protection board is to ensure, monitor the compliance and imposing penalties. Now, when it comes to penalty, this is where we have taken a leap from wherever to where. If 250 crores of is defined for a data where for a record, if so 10,000 records are seen as uh, has been willfully or did not do enough to prevent the breach, then it is 10,000 into 250. So this takes an astronomical figure here, and I think that is where I don't think there is any privacy law in the world today which has the monetary implication can be as high as this, and this is that way a very different law in India to see that kind of a fine penalty that's coming up.
Yeah.
So Shikhar, to your question, if it doesn't have the revenue, so there are provisions to say how the fines would be collected, and there's a very detailed section about to what level of insolvency would this lead to. But to safely assume that if you have committed a breach and your value, if the fine is less than this one, you can practically assume that the person is out of business.
Just adding to that, I think one important aspect is that today now because of this law and because of this privacy bill, the onus is on the data fiduciary to prove that they have put enough controls. They had the intent, they had the right intent to secure the privacy of the information in the event of a breach, and it's not going to be the other way around. So it is going to be the onus is on the data fiduciary.
So this is another fundamental shift that has happened. In the earlier setup, if you are the aggrieved party, it is for you to go and prove that they have misused your data. In the present act, it is the responsibility of the data fiduciary to say that they have not misused the data. So that's why I said the data principle has been made the king already, and that is what is a fundamental shift in the way, in taking the spirit of Supreme Court's judgment saying privacy is a fundamental right. I think this has addressed it in letter and spirit in full, to say that it is now the responsibility of the institution that collects the data. It is that responsibility to say, I have the consent, I have collected it, I have said that I'm using it for only this purpose, and I have to prove that I have not used it for any other purpose. I have to prove that I have not shared this data with any other person. All of this is the responsibility of the data fiduciary. And therefore, when it comes to the next discussions, so the responsibility of people collecting data now have a high responsibility of ensuring that they maintain auditable records, to ensure that they have the necessary controls in place. Now, typically, let's look at an organization perspective. We so and I'm so depending on the size of the enterprise, the organization chart can be shrunk or expanded differently, but largely the executive function has number of individual roles: operations, technology, finance, legal, and information security. Sometimes, as the organization matures, there is a separate risk function which reports to the CEO as well as to the board. There's an audit function which reports to the board, and the CISO somewhere plays a role in between. He is responsible for all of the security aspects. So far, this is what we have been seeing. Now, the act doesn't say anything. So this is CIRAC sticking out its neck and saying some things here. Okay. Now, what is it? Where does the data privacy officer ideally belong? In some companies, data privacy officer ideally belongs to the it ideally belongs to operations. Now, some companies are extremely tech focused, and therefore can leave it under the CIO's office. Some companies are may not have an operations who have a knowledge, and they are actually, I've seen companies who have data protection officers under legal as well, because privacy is a legal subject and therefore it is under legal. Now, this is where in many companies they have actually built it under legal, because of the traditional function of how privacy has been dealt so far. I think this is where some collaborations are extremely required, and the digitization of the economy has made sure that the digital records, how it is maintained, is, the controls are essentially with the controls are essentially with the technical controls, and the governance of that is left with the CISO's organization. So we feel that organizations need to bring in and necessary training, the necessary legal training for the CISO, or having adequate collaboration with legal, so that the privacy governance can be adequately addressed from the CISO's office centrally. While this is one way of the governance side, from an execution point of view, for your organization to know, typically how do you go about and say, how do you know whether the risks are addressed? It is typically addressed through a risk assessment process. A risk assessment process would go through the risk universe and say, my organization is subject to this kind of risks, and therefore you build the control environment around it to build a security program. Privacy has the same level of detailing that needs to be done. A privacy impact assessment needs to be done, because at what place, when you're collecting forms, you're writing physical forms, you're writing digital forms, you're collecting privacy data. What constitutes privacy data? And Sudhir, your question is, if phone number and name treated as privacy data? Absolutely yes. Phone number and data is treated as privacy data. A WhatsApp group has participants, so uh, the WhatsApp group is an informal group.
It's a voluntary group.
It's a voluntary group, and you have provided explicit consent in the way the WhatsApp agreements are done, and therefore the admin of WhatsApp may not be liable because of one number being displayed to the other. If that question is, if your question was alluding towards that. Okay, so privacy impact assessment is an absolute must for organizations collecting data from end users. Now, this will lead you to understand where your privacy data is present, how it is present, and therefore you can apply the necessary treatment accordingly. Now, ideally, this program should be conducted together so that you have a full view. We have to move away from the standard model of just a risk assessment. We should now start including risk plus privacy assessment. Just like how business continuity has business impact assessment as a BIA, as we say, as an independent function to understand the business prioritization matrix. This is going to be very important to have privacy assessment along with risk assessments to be done, so that it has so this is going forward. Practitioners need to start getting putting their artistic view to see what is the right way to bring the privacy element into the fold into one assessment model that may actually be working out, because the same people are not inundated with multiple requests for assessment, and therefore we can have centralized data from one source.
So in continuation with what Suresh, as we take the step towards privacy and being compliant with the privacy bill, so we need to take into consideration the privacy impact assessment, and your risk assessment is going to go along. But I think in an important question, and what is it for the data fiduciary, and what is the action items, or what's next for that? Because at the end of the day, everything comes back to the data fiduciary to make sure that they collect the data, they secure the PII of the individual data of the data principal, right? So to start with, what I would kind of suggest here is that you first read the act, do a current state assessment as to where you are with the current the privacy bill, and then have to do a very deep dive privacy impact assessment to identify the PIA data across your systems, applications, and other processes that you have. So when we say this, I think this is the time for you to understand the data flow within your system of how private PI data or any application per se, what data is it collecting, whether it is PI or not.
Okay. So has relevance to Ganesh Raja's question now that is being posed. If the consent is not directly taken from data principal and the data principal not voluntarily provide his data, then the right to access and right to correction is not applicable to data principal. No, sir. If you have explicitly or implicitly collected data, it is the responsibility of the data fiduciary to own up to that and say, I am responsible. Even if you don't, the act per se has already given the complete ownership of keeping the data in the right way. and to obtain the consent in the right way to the data fiduciary.
Yeah, they cannot collect the data without the consent. Okay. Anyway, so yeah, so I think identify the data elements, right? Identify all the data elements in your system, PI data across your applications, and find out which applications is going to store what PI data, whether it is Aadhaar, whether it is just a mobile number and an email ID, or whether it can be sometimes even health data, financial information, or sometimes the insurance data as well, right? Then based on this assessment, you understand which systems has what data, and the next is to draft the policies, create procedures, or rather at the design level in the organization, how as a data fiduciary are we going to comply, and show the intent in the organization that we have the intent, or we are going to implement controls in line with the privacy, right? So you draft your privacy policies and establish assign your data protection officer, assign the roles and responsibilities of each of the stakeholders involved, whether it is it could be additional responsibilities to the security officer, additional responsibility to the chief information officer, right? And so once you establish that is when you start implementing the controls, right? It is, and this implementation of the controls is going to be in the systems application of the system, and it's two ways. One is the implementation of the IT controls in the system for the system to be ready to be compliant and secure the privacy data. The other is also to set up systems across the organization to handle the data requests that may come, right? Whether it is the grievance and the redressal mechanism needs to be updated, whether it is how am I going to take a request from the a data principal, or rather if I have to put it, how easy am I going to make the data principal submit a request, and how am I going to act on it? What is my timeline? What am I going to tell back to them? And then next is really securing the data. I think the security controls to be implemented. I think as a security firm, I'll be interested encryption, pseudonymization, and anonymization. And then along the way, like I said, along the life cycle, decide how long you want to take the data. Make sure that you're going to keep the data safe for that period and delete it once the life cycle ends. The last one is having a breach notification. I think in the event of a breach, who are all the stakeholders you're going to inform? Whether it is from the regulatory to certain, and also now the additional responsibility could be to inform the board if they have to constitute and say. So all this have to be taken care, and this is what I think as data fiduciaries have to focus.
I think we may need to look for more information. So there are questions like what Viral Gandhi has asked, what class of entities are likely to be notified as significant data fiduciaries? See, I think large. See, we are making an assumption here. Yeah, when the act is not explicit on defining that yet, we are seeing that it is essentially trying to look at people who collect large information and aggregate that information and use for cross selling that information explicitly or intrinsically. So that is what they are very concerned about. And so there are multiple questions that has come. So we will quickly wind up our presentation. Very quickly, if I have to summarize this act is one made very simple. It has been written in an, the primary objective was to say that provisios have to be taken off. Very little of legal knowledge required to understand. A person with English knowledge can take a download copy of this, understand. Chances that they will interpret to 85% of the act in full is possible. I think that there are a number of things that have been done which are very different from what has been done so far. So this is a Common Man's Act, and therefore it has reached. There is number of efforts to take to reach it to the common man. I think to that we kudos to the lawmakers who made it happen this way. We should be really proud of such an act that has come up our way. I think very important is for organizations collecting data is to see what responsibilities now do we have and how do we start building a privacy program that is commensurate to saying whether it is sufficient or what needs to be done to comply to this info. I think the steps that Venkat told, articulated in the earlier, I just put that slide again back for them to understand. I think these steps are absolutely required for making sure that you comply to this. You can do it yourself. You can consult with privacy consultants like us to do that for you. But very important that it is now imperative for organization to have this in place, and it is mandatory to have it in place. Right. With that, we will move to questions, so if we can start looking at the questions.
I'll read out some questions I noted.
Why don't you go to the Q&A?
Not everything has come. Some have come on the chat, so I just made a
No,
note.
let's go to the Q&A. People who have put it in Q&A, so that way it's
okay. Yeah, 1 second. So one is on what is the role of a consent manager with data fiduciary by Veeral Gandhi.
No, let's look at it here from these sections here. Sandeep, your question: we are storing the user's personal data for logs and debugging related tasks for our client. Then what is the process in how are we to comply with this act? If you are storing personal data for logs also, you become a data fiduciary, and therefore you will need to take consent for the purpose that you are doing it. But if you are doing it as a tech partner on behalf of your client, then you are not a data fiduciary, you become a data processor for that purpose.
I think the bill also brings out this data in use as a word, brings out very interesting.
And Harshit's question, what constitutes as reasonable? See, this is an evolving, the threat landscape is evolving, and therefore we can't expect the act to specify what security measures to have in place. You shall have this, you should have this, and that. See, and therefore the law will always mention as reasonable, and I don't think we should be worried about that aspect. For example, the IT Act said reasonable security practices, but RBI's cybersecurity framework is not talking reasonable security practices. They have gone ahead and said, using the same law as the IT Act, reasonable security practices, they went and said that you should have a firewall in place, you should have a designated CISO in place. So I think it is for nodal agencies who have the responsibility to come out with multiple things that are specific. So health ministry could have their own, finance ministry could have their own, and individual pharma could have their own, and so on and so forth. So it will evolve. So telecom data could be dealt differently. This is going to be dealt differently by different people, by various nodal agencies that will come up from time to time. So this reasonable is very reasonable in my opinion. Is there a timeline for data principles request within which data fiduciary has to comply? I think the apart from some other exceptions, this is you have to comply from today. As Mr. Krishnan's question, as a software supplier under SaaS model, the data is stored outside India and used by our clients who collect personal data. Used by your client, the client becomes the fiduciary, As a software supplier, you become this. If you have ownership to that data in some form, you become a data processor, and you are liable to the data fiduciary and not to the data principal directly.
Okay.
Neha Jacob asking, what about the candidate data that an organization collects at the time of joining or from time to time during the working tenure? It is part of privacy data, and the organization that collect will have to be protecting that data and shall not use this. A very important aspect is a company for hiring, unless it's very large organizations, they're talking about companies that collect data. It is, even though it is small, you have to ensure that the data is used and accessed by people only to whom they need to have it, and therefore it's not open. And second, as a company storing that data, you are not sharing that further to other people outside of the information why you shared that information. That's very important. You can't say, I have, in the last 4 months, I have collected 4,000 CVs and I have their address and telephone number. So you can give it to another company to use that for cross-selling. If you do that, it is considered a breach in this process. Okay, that's how the act has to be implemented. How do we, Divya's question, how do we address personal data circulating amidst NGOs, and will they be liable to these fines as well? If the NGO is collecting the information and they have to use it exactly for that, so consent has to be taken. So NGO is part, they are not exempt from this. How does an organization ensure compliance? The policy does not take up measures to protect data privacy. To which there has been a privacy, whether there has been a privacy breach that has already happened. If a breach happens after the act has been passed, whether you have collected the data prior or not doesn't matter. You are liable to the same fines.
And I think one addition is that data fiduciaries who have already collected the data of the data principals will have to look at sending a notification of a consent, right? That has been, we have already collected your data, and have to send out a notification. That is also as part of the law. And that is an important action item for the data fiduciaries as well.
Ganesh Raja, your question requires a lawyer to answer. Can we use a legitimate interest as a lawful basis as per DPDPA? I honestly didn't understand it in full. So if you can elaborate again, we will try to answer that. Gopal Chand, does this act also says to provide option to end user to update or delete? Yes. Correction of data is addressed. So the same provisions of consent consent is required, and why you are giving this data, and they have to use it exactly for that reason. That is sacrosanct. That cannot change. And if you are giving consent, you have to give consent exactly to that. And if the fiduciary is asking, can I use it for additional upsell? Can I use it for data analytics purpose for here? Can I use it for data aggregation purposes? They have to mention all of this in the consent. Okay, Sunil Mahajan, your question: if I'm a document storage company and storing financial documents where I do not have any requirement to look at the contents of these documents may have PIS, but as a storage company, I do not look at these concerns. You do not have any role to play if you don't have access to that data at all. As long as you're a provider and you are providing the data and you can prove that you don't have access, you are just a platform company providing storage. You don't have the responsibility to
to privacy.
To
And
privacy.
adhere to the agreement with the service.
So, but however, please ensure that your legal provisions adequately address that in the way you are having with your with your clients, because the clients could use it for dumping any data and you have no control over that, and you should make it explicitly clear in that, and you should ensure that you don't have access to that data in any form or other. If you have access, then you become liable.
You go to chat, you will see more questions.
There are more questions here. Akshaya, is the data like name, phone number, email ID collected from various social media and used for cold emails activities regarding marketing? Do we, if the company that is doing cold emails are collecting from publicly available social media, you really can't go back to them and it is not considered a deemed consent, nor it is a consent. It only has to be, you can only take a legal action against them that such act is being committed by them. But is the company that is doing cold emails in breach of the contract? Yes, they are collecting that and using it in breach of the contract. In whichever way they collected the information, they have used it and they have committed a breach.
You go to chat. One of the questions I think from Rahul was, have timelines been defined for
the act is live. It is
for responding to the request of the data principals, right? For a data fiduciary. So
the complaint mechanisms have not been defined through circulars. The appellate authority has not been found. So there are a number of things that are still in motion. So we will need to definitely see the dispute mechanism and the complaints, redressal, grievances, how that is being addressed needs to be seen, and we don't have much clarity on that yet.
Yeah, and I think again the word reasonable comes into place for responding to a right to erasure or a right to update the request. I'll read one more question here. What kind of documentation should we have in place to be compliant? What should be displayed to the end user, roles and responsibilities? This, I think
the consent has to be made explicit that I am collecting this information for this purpose and I shall use it only for this purpose. I think that is mandatory. I think that's the key that needs to be addressed.
And one more question from Akshaya is there any update on the timeline to notify both data fiduciary or data subject in the event of a breach? And I think like all regulations and the current laws follows in terms of notifying your data fiduciary or notifying your client or notifying the certain or regulatory body in the event of a breach. That continues, and in certain cases it is within 6 hours when it comes to certain. But additionally, once the board is formed and
the breach of, we'll assume for a minute that what Venkat is saying, that the breach of privacy data is essentially through a security breach, and then certain regulations are already there. But if the breach has not been through, has been through an internal process where you did not have, people had access to information and therefore not considered a threat actor doing it, but by having a suboptimal operational process, then whether it needs to go to certain or not is not clear in that. So which authority needs to be notified of this, so all this will become more clear when we have the data, the DPB and the role and how that is going to be set up. We'll have more clarity on that. So with that, I know we haven't answered some of the questions, but it is our promise that we will get back to you with our answer for those questions that were not answered. we will definitely do that. So please, thank you for asking these questions. We have, if we have tried to jump or try to answer questions faster than where we should, we will try to look at all these questions and send you appropriate response. Thank you so much for being patient listeners to this webinar. We enjoyed this session with you, and thank you so much. We will look forward to yet another webinar yet again from Cyrax. Thank you very much. Till then.
Thank you all. Thank you.